The beauty of the informal trial process is it allows the litigants to tell their story without having to try to second guess what the rules of evidence, what the rules of procedure are.
The motivation behind this program was not to simplify this for judges. The sole motivation here for this program is to create a process that individuals can come in and present their case.
My hope is that it imbues some level of confidence as they watch us ask similar questions to both parties. I think there's an educational component to this.
Welcome. I'd like to thank everyone for joining us today. We are here today with our esteemed panel of judges from the Family Division of the 8th Judicial District Court. We have with us today Judge Duckworth, who's been serving in Department Q since 2008. We have Judge Parlade, who has been serving in Department A after being elected in 2022. And we have Judge Gordon, who was appointed to Department C in 2023 and just won re-election unopposed. Congratulations.
Thank you.
We're here today to talk about the newest rules in Nevada for the informal family law trial rules. These rules were just approved in November of 2024 by our Supreme Court. The rules are in place for a one-year pilot program, and there have been a lot of questions about them. So we've invited our judges to answer a few questions and explain to us how the rules work and how an informal trial process operates. So thanks for joining us today.
Thank you.
Thank you for having us.
First, why was there a need for an informal family law trial? Maybe I'll start with Judge Gordon, since he was the impetus who began the idea.
Well, it wasn't long after I was appointed to the bench that I realized that the large majority of the litigants that we as family court judges deal with and interact with are unrepresented. They don't have the benefit of attorneys or legal representation, and they are trying to navigate a very complex, complicated legal process on their own. And that's difficult. It's difficult for unrepresented litigants to understand the procedure. It's difficult for them to find their way into court. And then even if they're able to overcome that challenge, when they get in the courtroom, think about how overwhelming that can be, right? Judges and clerks speak in a parlance that is unfamiliar to them as far as legal jargon and terms. The procedures are something that lawyers spend years mastering and learning about. How can possibly an unrepresented litigant understand all that? So it seemed clear to me almost immediately that this process something needed to be either adjusted or changed to help meet the public and the individuals that we were trying to serve where they're at. And so that's where the idea sort of came about, the idea of making the process more user-friendly, making the process more accessible to the general public.
So if somebody chooses to proceed with an informal trial, what does that process look like? What can they expect on their day of trial?
The beauty of the informal trial process is it allows the litigants to tell their story without having to try to second guess what the rules of evidence, what the rules of procedure are. The same substantive law still applies for us as judges. For example, if we're doing a custody case, we still have to go through the standard procedure, but at least now it allows the litigants to be able to come in and present their evidence, whether it's, folders and binders or text messages, and not have to worry about whether or not there's going to be an objection, whether or not they can tell their story without worrying about objections or, hearsay and all of the other rules of evidence that could hinder them from telling their story. And so they can come in, tell their story, present their evidence, and lean on the judge. It takes a more active role for us because now we're going to partake in information gathering. And I typically, even before this, I would give custody cases, I would give them a printout of 125C. I would give them a printout of the best interest factors, and I would tell them, these are the factors I need to look at. And so now it allows us to do that question answer and say, these are the factors. Now you can tell me your testimony without having to worry about being objected to or having to try to figure out how to present like an attorney.
And I think it becomes more of a guided discussion. And as we sit from the bench, I think it's important. We understand the information that we're looking for. to make decisions that impact the litigants from custody to financial matters. And as Judge Gordon mentioned, sometimes it's very difficult for them to navigate the courtroom process. And it's happening at a time in their lives when oftentimes they're in a crisis. Emotionally, things perhaps are at their worst. They're fighting over issues that include custody of children, financial issues. So if we can ramp down the emotion a bit and have some type of a guided discussion, I think that benefits those litigants. The beauty is that these rules apply and can be opted into by even individuals who have represented counsel can opt into the informal trial practice, but it does benefit those who are unrepresented, where they have challenges just understanding not only the process, but when we start asking about rules of evidence that they're relying on, that's something that we shouldn't expect that they're going to be familiar with. Sometimes they surprise us, and they are. Sometimes they might be more familiar with the rules of evidence than some of the attorneys that appear in front of us. But I think it's a great mechanism to create a guided discussion to make sure that we receive the information we need to make the decisions based on the appropriate facts and the law.
And there's been some concern from some in the legal community that because the judge is doing all the questioning during the trial, there may be the appearance of bias or impropriety. What safeguards do you feel are in place to prevent that from happening? How do you ensure people feel they're being treated fairly?
Well, generally, when it comes to that issue, and I think that's a significant perception that may be created just based on the questions that are asked. But oftentimes, as I approach the issue, say, for example, the custody of a child, I'm going to be asking the same or similar questions to both parties. And hopefully that's one mechanism so that both sides understand that it is a fair, impartial process where I am simply seeking to obtain the factual information I need under the law to make those important decisions. So generally my approach is going to be to ask very similar questions. Now, it may be slightly different depending on my familiarity with the case and what the parties have disclosed at a prior hearing, a case management conference, for example, or something they've written in pleadings. There may be specific issues I need to address with one specific party because it's been identified in the papers. But generally, they're going to be similar questions. Now, the practice itself, the rules, the informal family law trial rules allow the parties to inquire or at least ask the judge about a specific issue, and then the judge may tailor questions specific to that issue as to one party or both, depending on the specific facts of that case.
If I can just add to that response, one of the advantages of an informal family law trial is essentially addressing that concern, because a judge is letting the litigants know in advance that the judge will be doing the questioning, that you can expect, each of you can expect questioning from the court, so that when the judge asks questions, it's not perceived as bias.
So there's an expectation
that you'll be asked questions and that the judge will be driving the question.
Right.
Yes.
What if one side really wants to ask questions of the other side?
Well, understand that an informal family law trial is not forced upon anyone. So, and litigants are advised in writing as part of the selection form that they must sign that they are waiving their right to ask questions of the other party. So if a litigant, and a litigant is reminded of that by the judge at the beginning of the proceeding, so they're making an informed choice to select this process. If that's something that they don't want to waive, if that's something that they want to have the ability to do, then this may just not be the right process for them. And that's okay. That's okay. They can, it's not for everyone.
And certainly the rules allow that litigant to ask the judge to inquire into a particular area. And then it would be up to the trier of fact, the judge, to make a decision as to whether or not that's a proper inquiry, that's a proper line of questioning, and certainly we can explore those areas. But I think that's important to note that when someone is opting in, and this includes attorneys as well, when they're opting in, they're essentially leaving that questioning up to the judge.
And so just to be clear, if one party wants the traditional trial, but the other party wants the informal trial, which is the route the trial is going to go?
Traditional.
Right, the rules require that it has to be an opt-in by both sides. Both parties need to opt in to the informal family trial.
And with an informal trial, under our traditional trial rules, there are lots of requirements to submit pretrial briefs, closing arguments at times, lists of exhibits, lists of witnesses. Do all of those still apply to an informal trial, or are some of those issues relaxed?
Well, under the rules, all of those requirements still apply. The rules of an informal trial only modify or change how the trial itself will be conducted in the courtroom that day. That's all that's modified. All of the rules leading up to trial, all of the discovery requirements, any disclosure requirements that are under our rules of civil procedure, all of those still apply to an informal trial the same way they would to a traditional trial. We're simply changing the way that the trial itself will be conducted, and we're modifying it in a way so that the process can be more comprehensible to the litigants who have to navigate that process.
I think one important note in that regard in terms of managing that trial is perhaps a slight adjustment to the issue of non-expert witnesses and that's covered by the rule. So a non-expert witness, say a family member, a co-worker, someone we might call a lay witness in legal parlance, that is someone that you affirmatively need the court's permission to have them called as a witness. And so I think it is important prior to the trial to have some discussion, because some aspects of this can be managed prior to the time of the trial. And so I think it would be important perhaps to have a discussion about, are there other witnesses beyond the two parties that you expect or anticipate would be called at the time of trial? Now, it doesn't change the requirement, as Judge Gordon mentioned, about having witness disclosures. That may be something that we order as part of a case management conference, that you have a deadline to list names of individuals that you intend to call as witnesses, and say, for example, you elect later to conduct an informal family law trial, then the discussion perhaps at the beginning of that trial is the extent to which those witnesses will be called, and there might be a brief discussion about the information that is going to be obtained from those witnesses. But again, it's the discussion that is led by the court at that time in conducting that examination.
So since non-expert witnesses have to be approved by the court to testify, does that mean under normal circumstances only the parties would be the witnesses?
I think that's the expectation generally.
And it's what's happening
in most cases.
Yes.
Yeah.
I mean,
Right.
It's very unusual for an unrepresented litigant to come to a trial wanting to call other witnesses. It's not that common.
But an expert witness is still permitted? Are there limitations to that?
It is still permitted, and again, I think that's going to be the very rarest of circumstance where a case requires the involvement of an expert witness and yet still finds its way into an informal family law trial. I just think that's going to be the very rarest or most unusual of case.
I think if an expert is involved, there's a good likelihood that at least one party will want the traditional rules to be followed.
There's lawyers involved.
Right.
Right. But it's still an option that is available, but it's less likely.
Do you believe informal trials would be shorter in duration and shorter in the amount of time to schedule, or how does that compare to the scheduling and the duration of a traditional trial?
I've conducted 4 of the informal trials already, and they are much shorter in duration because we can go directly to the heart of the matter and not have to worry about all the evidentiary processes. So I do believe we're actually looking at setting some setting slips now for informal family law trials so that we can stack, as opposed to having 1 3-hour traditional trial, we can probably stack maybe 2 or 3, but right now I'm trying to do 2. So they are much more streamlined and effective. In the 4 that I've had, they were just the 2 litigants, and it allowed them to tell their story. I gave them the law, gave them the factors. They went through the Q&A. Afterward, we took a break. I went on the record and then rendered my decision on the record, incorporating their feedback with the same best interest factors applicable. So it was much more streamlined, and it allowed us as the trier of fact to gather the information. And in the end, the litigant took that anxiety off the litigant of having to try to figure out what's going to happen, what is she going to ask me, what's he going to ask me. It doesn't allow that cross-examination. And it allows both parties to know transparently, these are the factors I must consider. I'm going to ask you the same questions, and I'm going to need you to give me your information.
And if I can append to that, I think what needs to be emphasized here is that the motivation behind this program was not to simplify this for judges. It was not to relieve burden on our dockets. That was never the intention. The sole motivation here for this program is to create a process that individuals can come in and present their case, a case regarding custody, regarding their children, a case regarding a divorce, issues that are so personal and important to them, and do it in a way that they can understand, that they feel like they can be confident about, they understand the rules by which the game is being played, and so that when that case is over and a decision has to be made by one of us affecting those very personal and important rights, that they feel, whether the outcome was in their favor or not, that the process was fair and that they understood what happened. And that is the primary motivation behind this program, and I hope that that's what we're achieving by doing these trials in this way. And if I can just add, because this is something that I've said before and I'll say it again, it's not an inferior trial. And I think that there is a perception that these are inferior trials. They're informal trials, and there's a very big distinction.
And on that note, there's again concern in the legal community that rules of evidence are being ignored, rules of hearsay are being ignored. What is your response to that?
Well, let me just add, in that regard, the rules of evidence exist to ensure or help protect the accuracy of the information that we receive. That really is the purpose of any of the individual rules of evidence. We want to make sure that the information that we're receiving and making these decisions is as accurate as possible. Hearsay is one of those rules we hear bantered about all the time, and certainly during this process, the rules are relaxed. We're receiving information that there might otherwise be an objection to under the rules of evidence. And oftentimes our litigants are not going to be familiar with those rules. And when we have regular trials without the informal practice and an objection is made, ultimately that's the question we have to ask is, okay, there's an objection. Can you cite to a rule of evidence as to why that information should be excluded? So I think on an informal practice, given the issues that we're dealing with, we, as triers of fact, as judges, we have to determine whether or not the information is accurate. And sometimes that requires some level of weighing. And that's really what the informal rules speak of. We're going to receive information that maybe there is a rule of evidence that might exclude that. Rules of evidence are intended to protect the record. Our responsibility is to ensure that the information we're receiving, regardless of those rules of evidence in an informal practice, still is that accurate information. Can we rely on that information to make an informed decision regarding those issues? And so yes, the rules are relaxed because oftentimes our litigants, they're not going to be well-skilled or well-versed in those specific rules of evidence. And so we need to understand the rules of evidence in terms of not necessarily being exclusionary, but in the manner of trying to protect the information and make sure that the decision I'm making is based on accurate facts.
Yeah, and to the extent, as Judge Duckworth said, the rules of evidence are there as a source of protection. But if the litigants don't understand those rules and they're not able to navigate them or use them effectively, then they don't provide any protection. And so in a sense, by us relaxing them, it's not necessarily altering the substantive validity or accuracy of the proceeding, because most likely those litigants weren't going to be able to use those rules either to their advantage or disadvantage because they don't understand them. So it was sort of like, why are we trying to adhere to standards and apply rules with individuals that can't be reasonably expected to understand them, right? So that was the premise for why let's relax them and let's let people tell their story in their own words and think about the power of that to an individual who has to, be in a courtroom fighting for custody or, of a child, right?
Let's say a litigant is displeased with the outcome of the informal trial. Do they have the right to appeal? And if so, how is the record on appeal preserved? Is there a concern the appellate court would not have adequate information to review the decision?
Yes, the same standard rules apply for appellate procedure, so they can still appeal it with the same standard process. The record is on appeal, everything that we admit, because we're admitting everything as evidence, so it would be admitted. The beauty of the informal family law trial is that we render the decision on the record, so everything is there and preserved. And we do have, of course, their disclaimers or their waivers that are preserved and part of the record as well.
I mean, when we proposed this program to the Nevada Supreme Court, obviously that was a concern that we had to address with our appellate court. And so obviously before proposing it, we wanted to vet the program and troubleshoot it as best we could. Maybe this is a good place to point out that there are 7 other states that are using this program, the same informal trial program. This isn't something that Nevada has created out of thin air. This is a program that's already been tried and tested and working with great success in other states. So, but before we proposed the program to our appellate court, I did an extensive search of, courts in those other states, looked at their appellate decisions to see had anyone appealed an informal trial, to see what maybe there were concerns with or what might be trouble spots with a record or something to that effect. And I could only find one case that had ever been appealed that was identified as an informal family law trial. And the entire case opinion dealt only with the substance of the decision, and there was no discussion or any attention really paid to the procedure itself. So in preparing this program for approval from our Supreme Court, there was a lot of work done to see, are there challenges with the record? Are there going to be concerns? And I couldn't come up with really any. And I think Judge Parlade is correct that it's the rules, your rules to appeal and challenge the court's decision are intact. They're not. I don't think they're affected at all by electing for one of these trials.
And with an informal trial, is the public allowed to witness the trial? Are friends, family members, supporters able to attend, or is this done in private?
It's still a public proceeding. You've conducted 4, so.
I have, and I've allowed family members to come in. It's up to the litigants. I really leave it up to the litigants. If they're comfortable with their family members being there, then absolutely. I haven't had any issues with the 4 that we've conducted. I think it's a great support system for our litigants to be able to tell their testimony, tell their story, and know that there's their family back there. So long as the family members know that they're not allowed to participate or, chime in the background.
There may be a basis. For example, if the court determines that a family member might be a witness or might be allowed to testify, that one of us will be asking questions of that witness, that might be a basis to have them wait outside, that individual witness. But otherwise, it is a public proceeding, and family members are welcome to sit in the gallery and support. But as Judge Parlade indicated, they wouldn't be participating, they would be observing.
And we are very lucky here in the 8th to have a dedicated family division that is very, very busy, assisting lots of families in crisis. But this is a rule that applies throughout Nevada. Is this available in the other districts, in the rural counties, where maybe there's not a dedicated family division?
Yeah, I was pleased to see that our Supreme Court, when they approved the rule, that they did not limit it to our two larger metropolitan jurisdictions. It was adopted as a district court rule, which is a statewide set of court rules that apply to all of the different districts throughout the state of Nevada. It's not necessarily specific to the 8th Judicial District Court, which is the court here in Clark County. So it does apply in all of the rural counties as well. And before we rolled out the rules, we a couple of judges, a judge from up north and a couple of the judges here from down south, we put on a seminar for judges to help kind of introduce them to the rules and to sort of review them. And my understanding is our administrative office of the courts has now packaged that into sort of some online learning. So rural judges who may not have, have access to information and some resources to help them implement the rule. But it is available statewide.
And I've heard Judge Parlade say she has conducted 4 informal trials so far. How about the other 2? And are you hearing from any of your colleagues if they have been utilizing it and what their impressions have been so far?
So I've also been able to conduct 4. They've gone as I expected, and it seemed to be the litigants, when explained how the process would work and what it was about, it seemed like an ideal scenario. Everyone seemed excited about the opportunity, and they went off without a hitch. And so, and I haven't received any other feedback from any of my colleagues to suggest otherwise. So I know, judges are getting familiar with it. Judges are, they're having to navigate the new set of rules as well. So I think we're just only going to continue to get more feedback and hear more, get more information about how it's working.
I'm still waiting for my first. So my docket consists of 1/2 civil domestic. So I don't know if the opportunity is fewer and far between, but certainly it's something I have discussed with litigants on my civil domestic docket, and I look forward to being able to conduct this type of an informal family law trial.
Do you get the sense there's any particular type of case best suited for an informal trial, and in particular in regard to a high conflict custody case? Is that something that would be beneficial in your estimation? Generally speaking, we can't talk case by case, but generally speaking.
Yeah, I mean, one of the big advantages of the informal family law trial is that there is no cross-examination. Mm-hmm. So you're not in a courtroom where one parent is attempting to interrogate the other parent. And if you think about a high conflict custody case, as you indicated, that can be a problematic situation, right? Especially when you have litigants who are not well versed in how to craft an appropriate cross-examination question, but maybe rather are attempting to use that opportunity to argue their case or to prove a point. And so the elimination of the cross-examination really helps bring the temperature down in the courtroom. It really helps to eliminate some of the animus and the conflict that maybe is preventing these parties from reaching compromise, and by eliminating that helps the court now focus in on the information it needs for a sound decision making and to get to a result. So one of the big advantages is not having that, and I think that really does help at least try to mitigate some of the conflict that we see, unfortunately, all too regularly in our courtrooms.
Absolutely, I couldn't agree more. And that's why I'm a strong advocate for the informal family law trials, because it essentially evens the playing field and reduces that conflict to get to a place where it eliminates the mystery and the apprehension of what to do in trial. You know, the judge is very transparent. We begin the conversation with them normally as early as the case management conference, and then again at the calendar call to let them know this is an option. We provide them the material so that they can look at it, think about it, and by the time they get to trial, there's no surprise if they both agreed, you know, here's the law that applies, this is how I'm going to apply it, I'm going to ask you the same questions, and it really reduces that animus or that opportunity for any apprehension or, you know, the use of power and control to cross-examine and interrogate.
I think we all realize, as has kind of been a common theme in our discussion, these are the most personal issues for these individuals that are standing in front of us. And I think we all realize and understand the personal nature of these issues. And because of that, the emotions are always running high. And we understand that. And so I think that type of a guided discussion, my hope is that it imbues some level of confidence as they watch us ask similar questions to both parties. I think there's an educational component to this. They can grow in their understanding of the type of information that we're looking for because we are asking the same questions of both sides, and they become more familiar with the guideposts we have in making these very important decisions on these very personal issues. And so I think that process can help temper the emotions and develop an understanding for the litigants as to exactly the type of information that we are looking for to make decisions that impact them on such an intense personal level.
And one final question. The rules were approved on a pilot program to expire or be revisited this November 2025. Give us your best closing argument in favor of keeping these rules beyond the 1-year pilot program period.
Well, I mean, for me, that's a no-brainer. I appreciate that the Supreme Court wants to re-examine it in a year. I would get back to, this evolved because judges were already having to modify the traditional trial model where when there were two litigants in the courtroom with no legal training, no legal background, and no idea how to navigate a trial process. These judges were already having to reshape, change that format to fit the needs of those two individuals. What we've done by these rules is now put back in place a structure for the less formal process that judges were already having to use. And by doing that, we've established a set of rules that on 2 pages that individuals can read, learn, understand, and they can come into that courtroom feeling like they know what they can expect and how the process will be conducted. And they can leave that day feeling like, okay, the judge followed those rules and it was conducted in a fair manner. So it's a win-win from all situations. It provides the judges with now the structure that they needed because the traditional trial process was not working in those cases. And it gives litigants now an understanding of what the process will be and an ability to gauge and make sure that it was conducted fairly. So I think that when we look at this, or when the Supreme Court looks at this in November, I think they're going to see that the process is delivering exactly what it promised.
And I couldn't agree more. And going back to what Judge Gordon said in the very beginning, which prompted this, over 70% of our litigants are self-represented. So we recognize this won't work for everyone. Those that want to do cross-examination, want to do the traditional model, they're free to do that. But for that 70% that doesn't have an attorney, that don't know the rules of evidence, this allows them to come into a place where we can serve them. We're called to serve our public, we're called to serve our community, and we shouldn't have to elevate form over substance to such an extent. Now the litigants come in there, their apprehension, they're already anxious trying to figure out how to act like an attorney. Many times they would say before, I'm not an attorney, I don't know how to do this. Now it allows us as the judges that leeway to be able to serve our constituents in a way where they feel heard. They can tell their story. They don't have to worry about all the rules of cross-examination, whether or not I'm going to look at everything. Whatever you give me, I'm going to look at it. And then I'll assess the probative value and everything. So it really is about serving our public and letting them know that we're going to be transparent. We're going to show you this is the law that we have to apply, but I can't do it without you. I need you to tell me your story. Tell me why, I should give custody to you. And then when the family feels heard, there's a different you really feel justice is served. They may walk away not getting the result they want, but at least they know that they were heard and the process was fair, and that's the goal.
And I would just simply say ditto to what my colleagues have said. I don't know that there's much for me to add. I would just say succinctly that we've talked about the difficulty in navigating these waters at a very difficult time in individuals' lives. These rules allow our self-represented litigants to more effectively deliver their message, deliver the information that they want us to receive to make these decisions. And it's also a more effective mechanism for us to receive the information. So I think from their perspective, it's about delivering that information and being able to feel like they effectively can do so without hindrance. And from our perspective, it's an effective way to receive that information and make sure that we receive the information we need under the law to make those important decisions.
Well, I can't thank you all enough for the work that you're doing on behalf of the public in Clark County, and particularly on behalf of the self-represented litigants who are my soft spot since I work with them every day in the Self-Help Center. Anything the court can do to make the process easier to navigate is always welcome and appreciated on behalf of our center, my team, and the litigants we all serve. So thank you to the judges for joining us today and sharing with us the latest news on informal trials in family court in Nevada.